City and Westminster Properties, 1934. Limited versus Mudd, 1959. In 1941, Mr. Mudd, an antique dealer, became a tenant of the premises of City and Westminster Properties. To the knowledge of the landlords, Mr. Mudd had been using the premises for both business and residential purposes. A renewed lease of 1944 provided that the tenant could only use the premises as a shop. Mr. Mudd covenanted to do so, however, he carried on living there and even fitted up the basement for residential purposes. The landlords knew the defendant slept there on some occasions but did not know that the defendant was using the shop as his residence. Another renewed lease of 1947 contained a clause stating that the lessee could use the demised premises as and for showrooms, workrooms and offices only, and not to permit or suffer the demised premises or any part thereof to be used as a place for lodging, dwelling or sleeping. Mr. Mudd objected to the last part and the landlords took out the clause from the contract as long as Mr. Mudd signed it. In 1956, Mr. Mudd requested a new lease. The managing director of the landlords visited the place, discovered it had become tenants' residence. Subsequently, the landlords brought an action against Mr. Mudd to forfeit the lease due to the breach of contract by the defendant. However, Mr. Mudd counterclaimed, asking for the rectification. Main issues in City and Westminster Properties, 1934, Limited v. Mudd. Firstly, was a claim for rectification valid? Secondly, did the landlord's knowledge cause a release of the covenant? Lastly, could the landlord's promise to let Mr. Mudd sleep on their premises influence the decision on the forfeiture of the contract? Firstly, the defendant's counterclaim for the rectification failed, as he was in breach of the covenant. Secondly, the court held that despite the landlord's knowledge of the past breaches, the covenant was still valid. However, their claim for the forfeiture also failed in the court, since their promise to the tenant was the only reason why he signed the lease and entered into a legally binding agreement.